I'm Chad Main, and this is Technically Legal, a podcast about legal technology and legal innovation. Today's show, I'm talking to Michael Callier and Ed Sohn of new law company Factor. Michael's the head of legal solutions and consulting, and Ed is an SVP and head of legal solutions and products. Factor is a new law company. Some people might describe what Factor does as manage legal services or call it an alternative legal service providers or what have you. One of Factor's main focuses, and what Michael and Ed mostly talk about in this episode, is providing ongoing legal and contracting solution to in-house counsel and their legal teams. The way Factor describes it is that it has a niche focus on complex transactional work that pretty much forms the core workload of most in-house legal and contracting functions. Michael, Ed, and I talk about how all players in the legal ecosystem can work together to turn out efficient and quality work product. We go deep into how in-house legal teams, their outside counsel, and new law players like ALSPs can collaborate and maximize productivity by leveraging the strengths of each. Both Michael and Ed started on traditional legal paths before they made the jump to legal tech and innovation. Both were big law lawyers early in their career. Michael was at Davis Wright Tremaine, and Ed was at King and Spalding. Ed made the jump about 10 years ago to the alternative legal services world when he started working with ALSP, Pangea 3, and ultimately Thomson Reuters when it acquired the company. After Mike left the law firm world, he was in-house for quite a few years before he got the legal innovation bug. He was in-house at Nike and ultimately ended up on the legal team for Dairy Gold, which is a large dairy cooperative. It was in these roles that Michael started to wonder if there was a better way to get things done.
For me, what drove me there was a bit of frustration and some incongruence with my sort of natural way of looking at problems and problem solving. So as a traditional lawyer, I do enjoy practicing law. I'm still licensed. I've practiced for some time. It's a part of who I am. But I felt an inability to really access the overall problems that our business clients were trying to solve. And that frustrated me because I'm sort of an eclectic thinker. I like to connect the dots between apparently disparate elements. And so when I went in-house with Nike, I, for the first time, and this is after, being on a traditional legal track, discovered that there were lots of different problem-solving mechanisms out there. There's Lean Six Sigma, there's information management, there's, data science, project management, and different types of project management, and it was mind-blowing for me. And so when I discovered that, I just got on a track to understand how we can incorporate some of those different problem-solving mechanisms into the delivery of legal service so that legal service moves at the same speed and velocity as business.
Do you have a technical background?
Yeah, I have a Master's of Science in Information Management from the University of Washington. And the information school there, at the time I attended, was the number 4 information school in the country, and I think a few years ago it was the number 1 innovation school in the U.S. But that was something that I acquired after law school.
So what about prior to jumping into the law? Were you into computers? Were you into tech? Were you into project management? What drew you to that?
Really, I didn't have a technical background. I developed a technical background as a way to bridge the gap between, what I knew and what I learned as a traditional practitioner and what I wanted to do for clients and believed I could do. I just went on a path, and this was, as far as I knew, before there were innovation programs like at, Kent State, Suffolk, and so on. I just developed kind of my own curriculum, even at the University of Washington, to find information and, sort of subject matter that I could mold and shape into something suitable for the legal industry.
So Ed, speaking of technical backgrounds, I noticed that you got a computer science degree just down the freeway from me, University of Illinois, in the late 90s. So tell me about that. How do you go from that to legal? Because in the late 90s at the University of Illinois, there's a lot of people that came out of that school that went to Silicon Valley and shaped the internet as we know it today.
It's kind of like Michael. I actually didn't have any ambitions. Nobody had ambitions going to even getting a technical background before going into law to think that, we'd work in technology-enabled legal practice, or legal services. My journey was really, I went to go and become an engineer. I had always, throughout the course of my college career, started to discover an interest in the humanities that I didn't know was really there before. I was always kind of a math and science person. And just as a happenstance of the kind of economic conditions, the dot-com bubble burst while I was in college, right before I was going to recruit for my full-time job. And all the sort of easy jobs you could walk into with an engineering degree out of a top engineering school sort of suddenly weren't there when I was applying to jobs. I had, simultaneously started to kind of, again, investigate my own sort of interest in the humanities, had a minor in English literature, and I decided I'd apply to law school, thinking I would go and be like a patent lawyer, and like join the patent bar with an engineering degree as is required. That sounded cool. I did a little intellectual property work before law school at a law firm in Korea called Kim and Chang. I thought it was interesting. But once I got into my legal education, I learned that I really wanted to be a lawyer, and that sort of the logical thinking that goes with, engineering and science training actually applies really well in the legal field. And then what kind of sealed the deal was when I did my summer internships with King & Spalding and Cadwalader. I kind of split my summer between those two firms. And I decided I wanted to be a litigator. And so I went into litigation, and it wasn't IP litigation. It was just business litigation, commercial, class action disputes, investigations, et cetera. But the thing that I think is the tether that kept me into technology was just that I was working in an environment that was very not tech savvy. People would call me into their office to be like, how do I get my monitor to rotate? Or like, how do I whatever? And then sure enough, after a while, while I was doing, briefs and motions and tending to my practice, representing my clients, I developed, a real sort of fell into a natural rhythm around e-discovery, which is an obvious place where a lot of us enter into kind of the industry, where technology meets law and digital evidence and working with huge corpuses of big data and large, kind of structured databases. And so then that led me into kind of my career in the alternative services world in e-discovery managed document review at Pangea 3, onto a career doing product management and at Thomson Reuters, which again kind of went full circle with my technical background, and then leading technology and innovation at EY Law before joining Factor. So it's been a meandering journey. I'd say technology is not it was never linear. I don't think there's any magic formula that says when you have a technology background, you're going to bring that into the world in this way. But it was sort of there persistently. And like Michael, actually, I invested a lot more into technology enablement in services. We were just talking about this, which is really a human problem more than a technical problem, and really investigated that much later in my career, actually.
So let's talk about that. You're at Factor now. It's a new law company, alternative legal service provider, whatever you want to call it, whatever the chosen moniker is. Let's say you meet somebody at a barbecue, doesn't know what Factor does. What's the elevator pitch?
So the easiest way to put it is that, the 80-20 rule kind of way to put it, at least the talk track I've been trying out lately, is that we are the outside legal department to most of the world's largest and most high-performing organizations. Not outside legal counsel like law firms oftentimes offer, kind of like outside legal counsel as a service, but rather we are the legal department to the world, right? The workload inside of an in-house legal department is largely transactional, like more than 60-70% of it is just contracting in terms of their direct workloads. And that's primarily what Factor does, is contracting really at the level of complexity that in-house counsel usually takes, or like an in-house contracting function. And so the easiest way to say it is that, rather than going and building your own contracting function, your own legal department with an army of lawyers that handle all these contracts, commercial procurement, real estate employment, ISDAs, whatever, just use Factor. And we're sort of the legal department to the world.
Yeah, I think that's right, Ed. We help to solidify the position of legal departments as integrators. So legal integrators. When I look at legal departments that I've worked in, legal departments that we support today, legal departments touch every part of the business. And they're one of the few departments that do so in such a dynamic way, where the voice of the legal department has so much influence. And one of the things that we can do, and that we do as an organization, Factor, is to help our legal department clients leverage that connectivity and that influence in a way that helps to drive greater and more significant strategic impact.
One of the things we agreed to talk about today was the battle between using law firms, consultants versus new law. Do you really think it's a battle? I personally do. I think it is a battle. So do you agree with that? And if so, why is that? And how do we fix that? Because it shouldn't be a battle. we should just all work in unison?
Yeah, that's a great question. Ed and I were talking about that earlier as well. And look, I respect the perspective that it's a battle because some folks actually do hold that perspective. I don't agree that it's a battle. I don't think it's a battle between law firms and new law providers or ALSPs. I think it is, though, a battle against a particular perception that there is some incongruence between those two stakeholders.
Specifically, what do you mean, or what's the incongruence you're referring to?
Well, the absolute best thing that we can do for our clients, if we look at ALSPs and law firms, is to partner together because those two organization types have really different strengths. So when we look at sort of the traditional lawyer, where do they spend their time, how they've been educated, and so on. It's really about that advisory muscle, the subject matter expertise in a particular area, whether it's IP, trusts and estates, antitrust, commercial, whatever it is. Very, very focused and narrow. And some of the most successful practitioners are the most focused, and that's wonderful. ALSPs, on the other hand, what we're really focused on, in fact, or in particular, is taking that subject matter expertise and optimizing it so that it can be delivered to the right folks at the right time in the right format at the appropriate level of velocity to address, some of the business issues that some of that sort of high volume, high complexity work typically touches.
Ed, is it a battle?
No, I totally agree with Michael. I think that it should be a collaboration. And we have offerings at Factor that are really focused on driving that collaboration. When I was in the e-discovery document review world, we were able to kind of take a company whose inception was really at Pangea 3, focused on that competition with law firms who are still doing a lot of e-discovery document review and, going kind of an end run directly to the corporate client. And that could seem like really strong competition. Don't send it to a first-year associate at $250, $300 an hour. Send it to Pangea at 35, it makes a lot of sense. And so that did feel like competition, but actually it was disruption.
I like that. Disruption. That's better. I like that. Disruption.
And after a while, we were able to sell directly to law firms. And that was, the good work of my former colleague and good friend, Joe Borstein, who was able to kind of spearhead our law firm strategy and demonstrate to law firms that we're better at identifying, fact out of huge swaths of documents and be able to consolidate that in a way that made sense. And law firms started using us to a significant kind of fraction of our revenue where it was previously zero. So I don't think that at all, and we believe that that's the case at Factor. We believe that's the case in the transactional world as well, that there's actually operational and execution and diligence related tasks and even, drafting of certain side documents and agreements that we absolutely are the better fit solution for that workload. And that there's some disaggregation to be done, not to take work away from law firms, but to really unlock and enable law firms to live into their highest value. And so it really is about finding the different solution to the different workload. And inside of law firm practice, there are ways to even slice that up a little bit. But what we found is that there's actually a lot more receptivity to that now. With the legal demand and the law in the world being what it is, law firms are turning away transactional work actually, because of a lack of bandwidth, because they have sort of stuck to a model that has kept all of that into, the traditional model of legal services delivery. And the alternative legal service world is ready, and we're seeing a huge amount of interest in our ability to kind of collaborate on those matters and find ways to kind of work and serve our clients in a way that's truly like a win-win-win. There's a whole bunch of other data points out there that kind of signal that there's a real sea change happening. Clients wanting more partner build hours, clients going to law firms for, really that premium legal advisory work and putting a lot of pressure on sort of like first and second year billable hours and, not wanting to pay those, that on the junior leverage. And you're seeing rates go up by like 5, 10, 15% across the board in the last year and the coming year because there's a premium on that legal advice. And so law firms are more and more leaning into that space of that really differentiated, extremely high level of expertise, and alternative legal services are really coming into their own as, the best equipped to effectuate execution of legal workloads, not necessarily that high level legal advice but high levels of process expertise and high levels of operating stability and execution consistency. And so I think that it absolutely is not a conflict, because we should be doing different work and many times collaborating together.
When we come back in just a couple minutes, Michael and Ed explain why some legal problems may actually be business problems and how using the right tech, people, and process for the right tasks frees up attorneys' time to focus on what really are legal problems.
This podcast is brought to you by Percipient, a legal services company powered by technology. Percipient helps legal teams tackle legal operations, electronic document review, and process automation. Percipient services include managed document review, subpoena compliance, cyber incident response, and also helps legal teams provide clients with process-driven legal support. To learn more, visit percipient.co. Percipient. Legal services powered by technology.
We'll get back to my conversation with Michael Callier and Ed Sohn in just a second, but I want to let you know, if you go to tlpodcast.com, there's a dedicated episode page for every episode with show notes and more information about our guests and a lot of the stuff we talk about. Also, if you want to subscribe, you can pretty much find us wherever you get podcasts. While you're there, if you like us enough, hope you give us a favorable review. If you want to get a hold of me, you can find me on LinkedIn or on Twitter. My Twitter handle is Chad_Main. All right, let's get back to my conversation with Michael Callier and Ed Sohn of Factor. Michael's just about to fill us in on how it's technology and business needs that are driving changes in legal.
The thing that's really, driving the change, it's less technology itself and some of the circumstances that make technology necessary and also feasible to address some of the business problems. So we have, microprocessors are 4 million times faster today than they were when they were first created. 90% of the data that we kind of sift through today has been created over the last 2 years. Knowledge doubles every 73 days. These stats are amazing, right? And lawyers in the legal industry, we're traditionally knowledge managers, We're managing information. We're trying to help clients kind of sift through all of this data, information, and knowledge to make smart business decisions that mitigate risk. And so with that increase of information, there's a need for tools, and not just tools, but sort of a mindset, skill set, and tool set to navigate that new environment effectively, to continue to do the good work, that law firms are known for. And that's really what's driving the change. And so when we find technology that actually works, it is designed to help lawyers get back to lawyering, the thing that lawyers are good at and do well and clients pay them for.
We hear that all the time, though. Let ALSPs do this bucket of work. It will let you do real legal work, high-value work. How do you convey that? How do you explain that with some real-world examples that, hey, this will let me, as a law firm lawyer or an in-house transactional lawyer, do the stuff that's really important that I should be doing rather than the more tedious stuff?
An example, let's take a simple example. Let's take playbooking as a knowledge artifact. So playbooking, it's just like with a football team, for example.
Playbook, you mean a playbook for how a particular type of contract is handled? That's
exactly right. So, the idea is that when lawyers or non-lawyer sort of paraprofessionals in legal departments have a clear line of sight as to what's coming and what to do about it in any given contracting situation, they can then use their creativity, their ability to manage some of the multiple variables that come up in a contracting environment, their proximity to other internal stakeholders and ability to influence and understand. It's a two-way street to do higher level work. And when we say higher level work, we're not just talking about, bet the farm litigation or, major acquisitions or that sort of thing. We're also talking about higher level strategic work, which is ultimately relationship driven. So the more time our internal clients have to focus on what they're best at, in terms of practicing law, but then also developing relationships with their internal stakeholders, understanding those business problems more intimately, and being a strategic partner in how the business navigates those business problems. That's what we're trying to optimize. And they're in a perfect position to do it And oftentimes they can't do it because they're drowning in, sort of process-driven problems and data-driven problems. And that's one of the things that we help with.
I think one of the things that, Michael, you tapped into that I want to really expound on is this idea that letting lawyers be lawyers is letting lawyers be like users. It's not about like, oh, hey, we are going to take all this legal work away from you, and so you're not really going to be lawyering anymore. It's more like, hey, we're going to make tech and processes and alternative ways that we organize how services execute on these workloads. We're going to make them different so that you're kind of users of them and not necessarily individual contributors on them all, right? Because it's not your highest and best use, to Michael's point. I think the other way I would put this that kind of goes to that user concept is like, it's about the user experience a little bit. And Chad, to be totally honest, I think that the alternative industry has a ways to go still. The new law providing kind of field of players, and also, frankly, kind of the legal operations movement for a second, which I hope it's not sort of, sacrosanct for me to kind of call out a little bit of an area of focus and improvement still for that movement, which is there's this weird kind of protest that comes out when they say, look at this perfect process and this workflow. I've engineered it. It's great. Look at this tech. It totally works. All you need to do is take 5 webinar trainings and spend some hours on like learning the platform. And then this should totally be able to turn these documents way faster. And like, why won't people do it? It's because lawyers are Luddites and they're so, resistant to change, et cetera. So this notion of like letting lawyers be lawyers actually is like coming out of one side of the legal innovation mouth, but then the other side of the mouth is like, why won't they change everything that they do and the way that they do it so that they can use what we've got for them and it'll make their lives so much easier? And we view our services in some similar ways, and that we need to teach clients to go on this long journey of like, interacting with new process and technology and innovation and an operating model and become business managers when nobody went to law school to do that, And I think that it's a user experience problem because from my product background, I can tell you that's not meeting lawyers where they're at. Meeting lawyers where they're at, if you're working with, a contracting alternative provider like us, it looks like this. One day you wake up and there's no more NDAs in your inbox. That's what it looks like. That's what it should look like. It shouldn't look like, oh, I got to interact with all these reports and like data and processes and check my dashboard, log into a new system where I can see where tickets have been allocated to approvals. And it's like one day you wake up and there's no more NDAs in your inbox. One day you wake up and every time that you get what is a relatively routine contract, it shows up in your inbox only on its third turn, where the redlining of most of the provisions has already happened. And there's only something that's really exceptional that requires a little novel legal thinking or someone that's much closer to the institutional legal positions of the client and where legal meets business and where in-house counsel should be really, very much in tune and in touch with, the objectives and the kind of core values of the business. Only then do we pull you in to kind of like review the contract. You're not redlining the same indemnification clause, the same limitation liability. Those emails are coming in your inbox on the third turn. Right?
Letting you be the lawyer. Letting you be the lawyer.
So letting lawyers being lawyers is actually an aspiration that has not yet materialized fully. And in fact, we're taking that really seriously. Like, we're not just going to teach them that there's this magical way that if they, navigate all these barriers, they're going to come to some summit that's going to be awesome. It's not painless and it's not fast and it's not free, but there is a way to make the user experience feel more like liberation to go be lawyers and less like, getting a degree in process and technology, And so if we do our jobs right, it really should allow lawyers to be lawyers. I just don't think that's totally happened yet.
So let's talk about that. Let's role play a little bit. Let's say I'm a GC of a big company, or let's say I'm in-house at a medium-sized company. And I've been reading these articles about ALSPs and new law and how, we can fit these pieces together, work in conjunction with my law firms. It seems pie in the sky. I come to you, Ed, Michael, like, what's my first step? What's the first thing I should do to get this ball rolling? Because as you just said, Ed, it ain't happening overnight. You can't fix all these problems overnight. So what are these increments? What's the first thing that you would suggest one of these in-house lawyers does?
Look, here's what we tell folks. Here's what I believe. And this is from, over a decade of refining how we help clients to solve problems. That's in the manufacturing environment in China. It's in, legal innovation. It's for, the last organization that I served. A problem well defined is a problem half solved. And so when a GC comes to us, the first thing to do is to try to get an understanding of what problems they're actually dealing with. Because all this stuff is use case specific. If someone says that technology is going to solve all of your problems, or even a process is going to solve all of your problems, that's impossible.
I want to emphasize that too, because, with all due respect to our colleagues in software, it is situation based, and there's no piece of software out there that's going to work for every contract or, every legal question that comes up, and it does require tweaking.
Yes, and it's interesting, and Ed was getting to this point, the tweaking is not just about tech configuration if we're talking about technology. The tweaking is also about literally the mindset and skill set of the users, and what personnel do we have in place to actually make this vision a reality.
Which is also a tweak to process, right? Like if you're going to move this person to do it, it's changing the process a little bit.
That's right. That's absolutely right. And so if we start with defining the problem and maybe a group of problems, because they'll have many of them, then we have to understand the root causes of those problems. Like what's actually making this thing such a problem, and for whom, and how do we know? How do we measure the impact of that problem? And once we have a good understanding of the problem statements and we look to the future and we have like these prospective desired future state in place, we have defined potential use cases for potential solutions, we got to prioritize. Where should we start? And when we talk about prioritization, there are multiple elements to take into account, like feasibility. Can we actually do this? And how much is it going to cost? How much time is it going to take? How much control do we actually have over this? And importantly, which problem, if we solve it, will resolve other problems that we've identified? So, the starting point, define the problem.
First of all, I have to say I 1,000% agree with that. The reason why consulting belongs inside of a managed services environment like ours, and why Michael has come on board and provided just so much value to our clients and to our company, is because of that. Most of the time, a problem well defined is more than half solved. It's clients coming to us being like, I need this. I got a 500 contract. I need this. It's like, well, okay. Do you really need that? It's like, well, just there's this software that I need. So I need that. Can you make that happen? And we're like, well, what's the root cause of why you have this need? How have you been doing this otherwise? Like, what are the pain points? Why are those pain points happening? Why are they happening in a place like your, legal department? Like really getting to that root cause and understanding, helping clients perceive their own needs is like the magic of good consulting, right? And there are charlatans out there in consulting. Like we know who the good ones are. We know that there are charlatans out there who are the smart brains that come in and say like, blah, like I've got a bunch of, like I'm smarter than you. That's why you want me to consult for you. And so here are all the answers. And like that, that's not totally without value, but it's not consulting. Consulting helps clients see themselves, right? And understand their own needs, and like puts that into really important perspective, because like we talked about at the beginning, law firms versus ALSPs, it's not about competition. It's different solutions for different workloads, and understanding who to go to requires understanding your own needs. I think the second thing of just like global advice to any GC is to learn by doing. It's as simple as that. Like you're not going to learn by theorizing. You're not going to learn by sitting back and waiting for it to be kind of like the sea change to flip to the status quo, where you're now the only one not using it, and I guess you'll just do it out of peer pressure. Like you learn by doing, you learn by trying.
Let's talk about that. Learn by doing. So again, go back to my original question. Yeah, we want all these problems fixed, but we can't fix everything at once. So what's a small problem? Where do you recommend them starting to learn by doing? What should they approach? What should they look at?
I think, first of all, you still start with consulting, because a lot of times what they think is their biggest problem may not be their biggest root problem. And so you always start with, whether that's hiring a consultant or whether that's just doing some of the hard work yourself, it's making sure you fully understand what is the kind of like the real problem that you want to solve, or what's the problem that you think you want to solve, and then like what's the root of that problem, right? So that you've got like a full understanding of that. And then secondly, I think it's identifying a relatively safe space to play, right? To say, here are a set of contracts that may not be at the highest risk, that may be an area that we're just long overdue to refresh that template, or we've recently had a lot of attention on it because it turned into breach of contract litigation, or like whatever it is, and it's a risk, but like it's relatively a safe space to try something and to say, okay, let's take this to a consultant, let's take this to let's get this templated and playbooked in a way that might be different than with the way we've historically done it, and let's get a small team over at an alternative provider to see if they can do this better than we can do this, to see if the economics make sense. And almost every provider out there is willing to try, have the right guardrails and constraints to do a pilot or a POC, just like you would for software. That's what I would recommend, is like, don't just, this is a great podcast. Definitely listen to podcasts, definitely learn, definitely accumulate knowledge. You're always going to learn by practice and not just by theory.
Agreed, 100%. A lot of talk in all industries, and legal tech is no different. Let's open up the black box a little bit. Let's say you've got a corporate legal department that's contacted you. You've identified some root causes. Let's keep it simple. Let's just talk about a volume contract, NDA. So they've agreed they're going to fix their process. They're going to bring in Factor to help them deal with this. What's it like to work? Like, what's a day in the life? I'm at a company, I get an NDA. What happens to it? How does it get to Factor? What's Factor do with it? How does it get back to the legal department? What are they doing with it? How does it get back to the final counter signatory, the counterparty to get signed? What happens there?
Yeah, so I would say before we fast forward to how what the day-to-day for a practitioner looks like with regard to NDAs, there's like some work that needs to be done to launch that particular solution. And the work to launch that solution includes, for example, defining the corpus of documents or the group of documents that we're gonna do. Are we, isolating that to sell-side NDAs as opposed to procurement or buy-side NDAs, for example? Have we predefined a hierarchy of NDA types? Country-specific could be a thing, right? Or a particular high-value strategic product or service that we still want some of that more white glove service or for an internal attorney to manage, as opposed to it going to a factor. So we have to define certain parameters around the type of, not just the type of work that we're going to do, but how we're going to do the work and what work that is. From there, when we're trying to define how this work gets done, that comes back to that playbooking artifact, right? Because what we want in terms of risk mitigation is consistency, consistent results. We can get consistent results if we can define what good looks like up front and then encourage folks to follow that particular path on a regular basis. Now, when we do that, we build that in, we also have to have a feedback loop, because there will definitely be circumstances that we couldn't have anticipated, but that will come up during the course of some sort of negotiation when we're talking about any sort of document. So we define escalation protocols. So if this happens, where should it go? And there'll be specific instances that we can immediately define as escalation requirements. Like if counterparty wants to tinker with your IP provision or something like that, immediately goes to resource X. At the same time, there'll be sort of a catch-all kind of escalation resource where if the escalation code or the reason for escalation falls outside of what we've predefined, then it goes to this other person. Now, the way that we use information as ultimately a valuable resource is when we have that escalation code that wasn't previously defined that goes to this particular person, we got to record that. Especially if that continues to happen, then that particular element becomes a standard escalation path, because we know that it'll come up over and over again, and now we've caught it. So once you build your system, then you turn it on. So it's interesting when we talk about systems. Typically, we're not talking about technology or just technology. We're talking about the people, process, technology, information, data, the thing that allows us to get from where we are today to where we want to be tomorrow.
From more of like a how would Factor roll it out perspective, doing all those activities that we do through, a lot of consulting and advisory work upfront, running through kind of like what we would call, before a deal actually happens, getting it properly scoped and good expectations. One of the things that's really important about providers like us, new law providers like us, is that we operate differently than law firms to the extent that we actually will certify things like SLAs, hold ourselves accountable to, SMART goals that are measurable and time bound.
A law firm SLA.
Yeah. Oh no, I don't know. A law firm SLA.
That's
I don't know if
that might be an oxymoron. Is that?
I haven't seen that in like an engagement letter before. I've seen some caps and collars, but I think and it's like get it done. So I feel like once we get to that point in the contracting, and then we can start to launch, and that user experience between buying and using, between selling and launching, is a really critical one. And it's an area where our consulting group has immense value to kind of be that point of continuity through that whole process, and getting in front of our people in delivery that are just an unbelievable group of people all around the world, but understanding how do we actually migrate this work into the factor world and start to move those NDAs, and how heavy do you want our tech footprint to be versus a lot of our clients invested into their own technology we can start using. And there's all these dimensions and how we integrate. And I'll kind of leave it at that, because eventually it kind of follows an implementation curve, and a lot of what Michael described. There's a continuous improvement piece. There's constantly kind of like living processes and living playbooks that are always being refreshed and updated, because it's never a one-time thing. And then you get to a point of steady state where it's like, it's just like an old shoe. We've always been there. And I think that I kind of want to just veer off this answer for a second and emphasize just one point, which is the notion of integration, that seamless integration. When we do this right, that's how our clients view us. And we're not the first ones to do this. I mean, like, I've worked at big enterprises that have outsourced their IT help desk, outsourced their HR, and they have your domain and your email, and like they may, even if we're not in COVID times, sit on a floor in your building, and their badge has like a little C on it or something like that. But they're really part of your company. They're really a part of your organization. They're the people that you eat lunch with. They're the people that that you call them, and you don't think of them as being an outside provider. And that is a tough nut to crack in the legal world. Legal tends to be like very, very focused, and smaller teams usually, and very selective in their hiring, et cetera. And outside counsel are sort of outsiders that need to be managed and coordinated a certain way. And so the notion that an alternative legal service provider could actually become a seamless integrated extension of a legal function is something that our clients have found very powerful with us. That when we're working on all cylinders firing and it's perfect, we're not a vendor being managed. We're really just a member of their team, right, and an extension of that function.
Right.
And so that's what we go for.
Right.
The one thing I'll just lob over as an idea is that, I hope that this podcast is radically out of date in like a year.
Oh yeah, you got some high aspirations, man. Me too, but
it's because our industry has no ceiling. Like, this is not like when you talk to an analyst, somebody like Ron Friedman at Gartner or someone else, like the alternative legal services industry has no ceiling. It is absolutely in growth mode. We're just hitting that diffusion curve of adoption, where we're getting now up that ramp where, it's not just the bleeding edge innovators that are trying this out because of some cost constraint, or it's like now becoming really status quo. But we haven't really started to explore what the upper limits of our work is. And people talk about like, well, regulatory, practice of law. Yeah, that's a very distant ceiling, if that is one. There's so much in terms of legal execution that can currently be done under supervision, or two people in the street can enter into a contract. They do it all the time. Like, there's so much that we can do to kind of execute on legal services. And I think that it is there's a Jevons paradox here. We're not just stealing legal demand from what other people are doing. When you have a utility of high value that it gets turned on like a faucet and like starts pouring resource into our clients, latent legal demand starts to pop up. Like, oh yeah, I didn't know that I needed this, but actually, yeah, I should sign this contract.
Interesting. I've never thought about that. That's a good point. That's a good point. Yeah.
And like, there's actually latent legal demand out there. And like I said, there's law firms turning away transactions. Like, we are going to be sort of a release valve for this industry in so many ways. And our ceiling is not yet defined. Our outer circumference of the pie is not yet set. And so I really hope that, this entire conversation is almost out of date, not because everyone has gotten on board the bandwagon and has adopted. I hear what you're saying. That's going to be slow going. But because the alternative service industry it's just getting started still. And we haven't seen the best of it yet. So I'm really excited about what's ahead. Excited to work with people like Michael. Excited for what we're doing at Factor.
And just add in one thing to that, I agree with everything that Ed said. The way that we get there, and this is what we're encouraging GCs and other purchasers of legal services to do, try it. You're going to learn by doing. One of the things that folks can do is, if you're really confident in a particular law firm or think law firms are the right resource, find law firms that regularly partner with ALSPs and incorporate that into your RFP, a requirement that the firm, bring an ALSP into a particular project or program. And if it's a smaller scale, try it. If there are problems that folks need solved and they haven't been, resolved by traditional paths, give an ALSP a shot, particularly where consulting is concerned, because, help you define the problem, help you define a future state, help you develop a roadmap to get there, and then come in with the appropriate resources, both ALSP resources and incorporating in law firm resources, internal resources, technology, to integrate the appropriate solution. And I guarantee the process in itself will be beneficial for GCs and other purchasers of legal services because of the learning benefit that will occur.
Michael, Ed, thanks for your time. Really appreciate it. Learned a lot of great info here. Michael, if people want to get a hold of you, how do they find you?
You can find me on LinkedIn, and you can, find me on Factor's website. Just give me a holler. Would love to hear from you.
Ed, people looking for you, where do they go?
Same thing. You can find me on LinkedIn. I make an appearance on Twitter every once in a while. And you can visit our website, www.factor.law, and you can get information about what we do and see our profiles as well.
Well, that's it for this episode of Technically Legal. We really appreciate you listening. If you want to subscribe, you can catch us on most major podcast platforms like iTunes, Spotify, Google Play, Stitcher, etc. If you like us enough, we hope you'll leave us a good rating too. Until next time, this has been Technically Legal.